Hello and welcome to the Deep Dive. Today we're taking a close look at some really fascinating concepts from the world of contract law. Specifically, how the law deals with situations where maybe the agreement wasn't quite as freely given as it looks on the surface.
Exactly. We'll be unpacking the doctrines of duress and undue influence, where we're going to explore how they've developed over time and why they're just so crucial for understanding when a contract, even one that seems valid, might actually not be enforceable.
Yeah, and this deep dive is based on some excellent educational materials made available by the University of London. We're really grateful to them for providing these resources for students.
We absolutely are.
Our focus today is squarely on the principles and the key cases covered in this particular document, really aiming to help you get your head around these sometimes tricky areas.
That's right. And this session is brought to you by Sinorbit Academy, Sri Lanka. We hope this helps clarify these important legal concepts for your studies.
Absolutely. And look, for all of you getting ready for exams, a really big good luck from both of us. We're going to try and cover all the key points, the definitions, the cases you need to know, hopefully get you really prepped.
Let's start by just sort of grasping the fundamental tension here, the balancing act. The courts are always performing.
Okay.
On the one hand, you've got this really powerful principle of freedom of contract, the idea that, look, if competent adults freely agree to terms, courts should generally uphold that deal.
Even if one side has more bargaining power.
Yeah, even then. The idea is to promote certainty in business and transactions. That's the bedrock, really.
The classic, you signed it, you're stuck with it sort of idea. Makes sense for commerce.
It does. But, and this is the crucial but, courts also recognize that consent isn't always genuinely free.
Right.
If one party uses illegitimate pressure, or maybe they abuse a position of influence to kind of force the other person into an agreement, well, that agreement isn't truly a product of free will, is it?
No, it feels wrong.
And the law generally won't stand by and let stronger parties take unfair advantage like that. There has to be a limit.
And this is exactly where duress and undue influence step in. They're the legal tools, the doctrines designed to deal with those situations where consent is vitiated. Is that the right word? Flawed somehow.
Vitiated, yes, exactly. Flawed or defective because of how it was obtained. And the law has developed these two main pathways to deal with it.
Okay.
Common law, which historically liked clearer rules, gave us duress. That started off focusing on really obvious threats.
Like physical violence?
Precisely. Whereas equity, which is more concerned with fairness, conscience, preventing unconscionable behavior, it developed undue influence. That looks less at a specific threat and more at the underlying relationship between the parties.
Okay, interesting. So different origins, different focus.
Exactly. Our mission today is to really explore these two doctrines, duress and undue influence, side by side. We want to understand where they came from, what their key ingredients are today, and really importantly, see how courts actually apply them.
Using the cases, the examples from the materials.
Yes, using the specific examples from the case law in our University of London materials. By the end, you should have a really solid grasp of how to spot potential duress or undue influence issues and how to start analyzing those scenarios you might face in exams or practice.
We'll try and make the distinctions clear, but also point out where they overlap, maybe.
We will. We'll highlight the differences, the similarities, and those little nuances that often make all the difference in applying the principles correctly.
Okay, sounds good. Let's unpack this then.
Yeah.
Starting with duress. That's the common law one, right? The response to pressure.
The common law's response to pressure.
So duress, you said it started pretty narrowly, like really basic stuff, actual threats of violence. That was it originally.
That was pretty much it, yes. The common law was quite slow, quite restrictive initially. It reflected a time when maybe the focus was more on the formal act of agreement. So it began with what we call duress to the person, essentially threats to someone's life, their physical safety, maybe unlawful imprisonment, used to force them into signing a contract. You know, classic movie scene, sign the contract or else, that kind of thing. That's duress to the person.
And that makes total sense.
Yeah.
You can't give genuine consent if someone's threatening to hurt you or lock you up.
Yeah.
The agreement might be there on paper, but it's not real consent.
Exactly. The law sees that kind of pressure as fundamentally illegitimate. It vitiates the consent, makes the contract flawed, and capable of being set aside.
Okay, so it started there. Did it expand?
It did, but slowly. The next step was recognizing duress to goods.
Threatening property.
Yes, essentially threatening to damage or destroy or unlawfully detain someone's property unless they agree to a contract or make a payment. The case of the Sabone and the Sabot tray from 1976 is often mentioned here.
What happened there?
Well, simplified. It involved ship charterers who were in financial difficulty. They basically told the owners, look, agree to reduce the charter rate or we'll go bankrupt and you'll get nothing and your ships will be stuck. The court recognized this threat regarding the goods, the ships, and the contract could potentially amount to duress.
Okay, so threats to person, threats to goods, and then the big one, the one that feels much more modern,
Yeah,
economic duress.
that's right. This is where the major development has happened, especially post-war. It's not about physical threats or direct threats to property anymore. It's about using economic power unfairly.
Like threatening to break a contract unless I pay more. Or threatening something that would cause me huge financial loss.
Exactly that kind of thing. For a long time, the law was very hesitant to accept that purely economic pressure could invalidate a contract. It was often seen as just, the rough and tumble of business.
You mentioned Stilk v. Myrick earlier, the sailor's case. Could that have been seen differently?
Well, it's interesting. Stilk v. Myrick is famous for the rule about consideration the sailors already being obliged to do the work. But one of the reports of that case, the Espinasse report, hinted at policy reasons, maybe concerns about the sailors putting unfair pressure on the captain mid-voyage.
So maybe a hint of duress even back then?
Possibly, but the consideration argument won the day historically. It really took until the mid to late 20th century for courts to explicitly accept that economic pressure alone, if illegitimate and compelling enough, could be duress.
And this often comes up when contracts are being changed or renegotiated.
Very often, yes. It's a common battleground when one party tries to force a modification of an existing deal. Think about situations similar to Williams v. Roffey Bros, where practical benefit was discussed for consideration, or where promissory estoppel might apply. Economic duress is another legal tool relevant in those contexts.
It's about leverage, isn't it? One party using their economic clout to force a change.
Precisely. Key cases that really shape this area include the Cibone and the Sabotre, which we mentioned, North Ocean Shipping Co. v. Hyundai Construction Co., that's famously known as the Atlantic Baron case from 1979, and also Pau on v. Lao Yu Long from 1980. These were pivotal in establishing economic duress as a proper ground for setting aside a contract.
Okay, the Atlantic Baron and Pau attack. Got it. Before we dive into exactly what makes economic pressure illegitimate, what's the actual legal effect if duress is found? Does the contract just become void, like it never existed?
No, and this is a really, really critical point to grasp, especially thinking about exams and practical consequences, particularly if third parties get involved. If duress is proven, the contract is considered voidable, not void.
Voidable. Okay, what's the difference mean in practice? Voidable means it's valid until challenged.
Correct. It means the contract is treated as valid when it's made, despite the duress. The consent, although improperly obtained, is still seen as, well, technically consent, but the victim of the duress gets a choice.
A choice to do what?
They can elect. They can either affirm the contract, basically accept it, warts and all, and treat it as binding, or they can choose not to affirm it. If they choose not to affirm, they take steps to rescind it, and then it becomes void. But it's their choice.
Why is that distinction between void and voidable so important? What flows from that?
Two major practical consequences. First, the person claiming duress the victim, they must act reasonably promptly to set the contract aside once the pressure is off.
Once they're free from the duress.
Yes. If they wait too long, if they carry on with the contract without complaint after the duress has ended, their inaction can be interpreted by the court as affirming the contract. They lose the right to rescind.
Like in the Atlantic Baron case you mentioned.
Exactly. That's the classic example. The shipyard demanded a 10% price increase because the dollar devalued. They threatened not to deliver the ship otherwise. The buyers reluctantly paid.
Okay, sounds like duress so far.
The court agreed there was economic duress. But the problem was the buyers waited 8 months after the ship was delivered, and they were free from the pressure before they tried to claim the extra money back.
8 months. That seems a long time.
The court thought so too. They said, by waiting that long without protesting, you've effectively affirmed the variation agreement. You lost your right to rescind because of the delay. So prompt action is crucial.
You can't just sit on your rights and wait and see if the deal turns out okay.
Pretty much, no. The second consequence of it being voidable relates to third parties.
Okay.
Because the contract is initially valid, if goods or property are transferred under that contract, an innocent third party who buys those goods in good faith, without knowing about the duress before the victim rescinds the contract, can actually get good legal title to those goods.
So it protects innocent people down the line who weren't involved in the duress.
Exactly. It promotes commercial certainty and protects people who rely on the apparent validity of transactions. If the contract was void from the start, title wouldn't pass, causing chaos for third parties.
That makes sense. Commercial reality needs that protection.
It does, and the Court of Appeal confirmed this approach in a case called Halpern v. Halpern. They said rescission for duress generally follows the same rules as rescission for other vitiating factors like misrepresentation. The remedy is basically avoiding the contract, setting it aside, but how that works practically depends on the case. The key is the victim has the power to avoid it, but it's not automatic.
Okay, got it. Voidable, not void. Act promptly. Protects innocent third parties. Let's get back to the substance then. What actually counts as duress? Duress to the person seems clear threats of violence like in Barton v. Armstrong.
Yes, Barton v. Armstrong involved death threats, pretty clear-cut. An important point from that case, though, is about causation.
Did the threat have to be the only reason they signed?
No. The Privy Council in Barton said if the duress was a reason for entering the contract, that's enough. It doesn't have to be the sole or even the dominant reason. If it contributed to the decision, the contract is voidable. That lowers the bar a bit for the victim.
Okay. And duress to goods threatening property, like in the Cibone and the Cibotre, also seems fairly straightforward.
Relatively, yes, unlawful threats concerning property.
Mm-hmm.
But the real difficulty, the area where most of the debate is economic duress.
Right. Distinguishing that rough and tumble of commerce from illegitimate pressure, how on earth do courts draw that line? Every tough negotiation involves pressure.
That is the core difficulty. Dyson J. put it very well in DSDN Subsea LTDV Petroleum Geoservices ASA. He said illegitimate pressure must be distinguished from the normal, sometimes robust pressures of commercial bargaining.
So just because I'm in a weak position and the other side knows it and drives a hard bargain, that's not duress. My business needs the deal. They squeeze me tough luck.
In essence, yes. That alone is usually just commercial reality. Inequality of bargaining power doesn't automatically mean duress. Most successful economic duress claims involve something more specific.
Like what?
Often, it involves a threat to breach an existing contract, unless the other party agrees to new terms, usually paying more or accepting less.
Ah, the pay more or I walk away from our current deal threat.
Exactly. Now, threatening to breach a contract is threatening an unlawful act, so that can be illegitimate pressure, but it's not enough on its own. The courts also require that this illegitimate pressure resulted in a coercion of the will sufficient to vitiate consent.
Coercion of the will. That phrase again. It sounds a bit like that old idea that the victim's will was completely overborne or destroyed. I thought you said courts moved away from that.
They did, conceptually. Lord Scarman used that kind of language in Pow on Villa Yulong, talking about coercion of his will so as to vitiate his consent, the victim having no alternative course, entering the contract against his will.
But that was criticized.
Yes. Academics like Professor Attia and later judges pointed out that someone under duress does make a choice. They choose to submit to the demand to avoid the threatened unpleasant alternative. Their will isn't destroyed. It's improperly deflected. They choose the lesser of two evils presented by the wrongdoer.
So it's not that they had no will, but that their choice was improperly forced upon them. The quality of the choice is the issue.
Precisely. The modern understanding, as articulated by people like Lord Hoffman and RV Attorney General for England and Wales, focuses on two key elements for duress. First, pressure amounting to compulsion of the victor's will, and second, the illegitimacy of that pressure.
Compulsion and illegitimacy, okay.
Illegitimate pressure usually involves a threat to do something unlawful, like breach a contract, commit a tort, or maybe even a crime. Threatening a lawful act is usually not illegitimate pressure.
Usually. Can a threat to do something perfectly legal ever be illegitimate pressure? That feels weird, like, pay me more or I'll exercise my legal right to terminate our contract on 30 days' notice as the clause allows. How can that be duress?
This is where the law gets very tricky and controversial. It's called lawful act duress. Courts are extremely cautious here.
I bet.
A case called CTN Cash and Carey v. Gallagher involved a threat to withdraw credit facilities, which the supplier was legally entitled to do. The court suggested maybe A lawful threat could be illegitimate if made in bad faith, like for a malicious purpose unrelated to protecting legitimate interests.
Yeah.
But they didn't find duress on the facts there.
So maybe, but very rarely.
Very rarely. The big modern case testing this was Times Travel UK Ltd v Pakistan International Airlines Corp. Remember this one?
Okay, times travel. What happened?
Okay, so PIA, the airline, basically had a monopoly on direct flights for Times Travel's customers. They
Yeah.
drastically cut Times Travel's ticket allocation and then said, we'll give you back some allocation, but only if you sign this new contract, giving up all your claims against us for unpaid commission under the old contract. And Times Travel. They felt they had no choice. Without PIA tickets, their business would collapse. They couldn't just switch to another airline. So they signed the new agreement, giving up their claims. Then they sued, arguing lawful act duress PIA's threat was essentially accept our terms or go out of business, even if terminating the old agency might have been technically lawful under its terms.
That sounds incredibly coercive. They were totally backed into a corner by PIA using its legal position.
It certainly sounds like compulsion, but the Court of Appeal held there was no duress.
Really? Why not?
The key reason was PIA's state of mind. The court found that PIA genuinely believed, in good faith, that they were entitled to demand those terms and to withhold the commission under the old contract, even if that belief might have been wrong or unreasonable.
So because PIA thought they were in the right, even if they were aggressively using their monopoly power, it wasn't illegitimate pressure.
That was the court's conclusion in Times Travel. They essentially said that using your lawful commercial position, even very aggressively, isn't illegitimate pressure amounting to duress if you genuinely believe you're entitled to do what you're threatening or demanding. They felt that controlling monopolies using their lawful power was really a job for Parliament or regulators, not for the courts expanding duress. This followed similar reasoning in cases like Borelli v. Ting.
Wow. Okay. So lawful act duress is theoretically possible, maybe if there's clear bad faith or malice, but extremely hard to prove if the party believes they're acting within their rights.
That seems to be the current position. Very narrow application. So mostly we're looking for unlawful pressure. But even then, that pressure has to compel the victim. How do we know if they were truly compelled?
Right. Back to compulsion. How is that judged?
This is where those practical factors, the indicia mentioned by Lord Scarman back in Pao on v. Lao Yu Long, are still super helpful, even if we've tweaked the underlying theory away from overborne will. These factors help courts assess the effect of the pressure.
What are they again?
Okay, 4 key things to look for. 1, did the person allegedly coerced protest at the time? Did they say, this isn't right, I object? Protesting strongly suggests they felt forced. 2, did they have an alternative course of action reasonably available? This is huge. Was there another option? Like, could they have just refused and sued the other party for breach of the original contract? Would that have been a realistic alternative? 3, were they independently advised? Did they get legal or other advice before agreeing? Having advice suggests they knew their options and made a more informed choice, making compulsion less likely. 4, after the pressure was lifted, did they take steps to avoid the contract, or did they just carry on as if nothing happened?
So lack of protest, having a reasonable alternative, like suing, getting independent advice, and then delaying any challenge afterwards, all those point away from compulsion.
Exactly. They suggest the party might have grumbled, but ultimately made a commercial decision to accept the pressure rather than being truly compelled with no practical choice. This brings us back to the Atlantic Baron. Again, the delay in avoiding the contract was fatal because it suggested affirmation, not compulsion.
Okay, that makes sense. It's a practical assessment based on conduct and options.
Precisely.
So let's quickly recap duress. It's the common law doctrine. Deals with illegitimate pressure, forcing someone into a contract, or often a variation.
Yep. Evolved from threats to the person to goods, and now includes economic duress, which is the main focus in modern commercial law.
Key elements are illegitimate pressure, usually an unlawful threat, very rarely a lawful act in bad faith, and that pressure must cause compulsion, effectively removing any realistic alternative choice for the victim.
And we assess that compulsion using those POW-on factors: protest, alternatives, advice, and subsequent action or inaction.
And crucially, the effect is that the contract is voidable, not void. This means the victim must act promptly to rescind once the pressure is off, otherwise they lose the right. And innocent third parties who acquire property before rescission are protected.
You've got it. While economic duress is recognized, courts apply it cautiously. They're always trying to walk that fine line between protecting parties from exploitation and not interfering too much with the sometimes harsh realities of commercial negotiation. 2, undue influence. Equities focus on relationships.
Okay, that's duress. Now let's switch over to undue influence. You said this comes from equity, and it feels different somehow. More about the people involved.
It has a fundamentally different starting point, yes. While duress focuses on the act of pressure, the threat, the demand made during the negotiation undue influence looks primarily at the relationship between the parties. Equity, acting as a court of conscience, is concerned about situations where one party has gained influence or ascendancy over another within a relationship built on trust or confidence, and then potentially abuses that influence to get the other party to enter a transaction.
So less about a gun to the head, more about, say, a trusted advisor misleading someone, or exploiting vulnerability.
Exactly. It targets the misuse of a pre-existing relationship of influence. Think about relationships where one person naturally relies on the other. Doctor-patient, solicitor-client, parent-child, religious advisor-disciple, maybe even just an elderly, vulnerable person relying heavily on a relative or carer for everything.
Or maybe someone inexperienced relying on their bank manager, like in that case, Lloyd's Bank v. Bundy.
Lloyd's Bank v. Bundy is a classic example often discussed in this context, yes. An elderly farmer relied heavily on his local bank manager, who then persuaded him to guarantee his son's business debts using his farmhouse, his only asset, without advising him to get independent advice. The bank manager was serving the bank's interests, not Mr. Bundy's.
That definitely sounds like an abusive influence.
It does. Lord Nichols, in the really important House of Lords case Royal Bank of Scotland v. Ettridge, No. 2, you absolutely need to know, Ettridge for undue influence described it simply as equity intervening to ensure that the influence of one person over another is not abused.
Ettridge. No. Okay.
Yeah.
That's the key modern case.
It is, along with Barclays Bank v. O'Brien from 1993. These two House of Lords decisions really clarified and structured the law of undue influence for the modern era, especially dealing with wives guaranteeing husbands' business debts, which is a very common scenario.
How did they structure it? I remember reading about different classes, like Class 1, Class 2A, 2B. Was that it?
That classification, stemming from earlier cases like Alcard v. Skinner and adopted in O'Brien, did exist for a while. Class 1 was actual undue influence. Class 2 was presumed undue influence, split into 2A, relationships where influence was presumed automatically by law, and 2B, relationships where influence had to be positively proved. But Lord Nichols in Ettridge, No. 2, thought those labels, particularly 2A and 2B, were causing confusion and weren't strictly necessary. He preferred to explain it more straightforwardly, although the underlying concepts remain similar.
So how did Ettridge explain it? Is it still basically two main types?
Essentially, yes. You can think of it in two broad categories based on how you prove it. One, actual undue influence, where the claimant proves, with evidence, that the wrongdoer actually did exert undue influence to get them into the transaction. Two, presumed undue influence, where the claimant establishes certain facts about the relationship and the transaction that raise a presumption of undue influence, shifting the burden to the alleged wrongdoer to prove the transaction was entered into freely.
Okay, let's take actual undue influence first. What does the claimant have to show?
They have to affirmatively prove it. They need evidence to show that. The wrongdoer had the capacity or potential to influence them. Influence was, in fact, exercised. The exercise of that influence was undue improper pressure, manipulation, taking advantage of vulnerability. It doesn't have to be threats like duress. And crucially, that this undue influence caused them to enter the transaction. There must be a causal link.
So you need positive proof of the improper persuasion or pressure related to that specific deal.
Yes, you need to show what actually happened. But here's a massive difference compared to presumed undue influence, and it's vital. For actual undue influence, the claimant does not need to prove that the transaction was disadvantageous to them.
Really? That's huge. So even if the deal seemed fair or even turned out well financially later on, if I could prove I was improperly pressured or manipulated into it through actual undue influence, I can still potentially get out of it.
Exactly. The focus in actual undue influence is on the wrongdoing in obtaining consent, not on whether the deal itself was bad. The House of Lords confirmed this in CIBC Mortgages v. Pitt. While the transaction was disadvantageous in Pitt, they made it clear disadvantage wasn't a necessary ingredient for an actual undue influence claim.
Okay, that's a really important point to remember. Actual UI, prove the improper influence, don't need to prove disadvantage.
Correct. Now let's look at presumed undue influence. This is where equity gives the claimant a helping hand with the proof.
How does that work?
Here, the claimant doesn't have to prove the undue influence actually happened. Instead, they prove certain facts that trigger an evidential presumption. The law then presumes undue influence occurred, and the burden shifts to the defendant, the alleged wrongdoer, to rebut that presumption.
And how do you trigger this presumption? Did Ettridge clarify that?
Yes, Ettridge explained there are essentially two ways this presumption can arise.
Okay, what's the first way?
The first way involves certain types of relationships where the law automatically presumes influence. These are relationships characterized by trust and confidence, where one party is generally expected to repose trust in the other's advice or guidance.
Like the ones you mentioned earlier. Solicitor-client, doctor-patient.
Exactly. The established categories include solicitor and client, doctor and patient, parent and child, where the parent is influencing the child usually, trustee and beneficiary, and religious advisor and disciple.
So in those relationships, if there's a substantial transaction between the parties that benefits the dominant party, the law just assumes undue influence occurred.
Pretty much, yes. Once the claimant proves the relationship exists, for example, he was my solicitor, and the transaction occurred, for example, I gifted him my house, the presumption of undue influence arises automatically. The claimant doesn't need to prove influence was actually exerted, nor that the transaction was disadvantageous at this stage.
Wow. So the burden immediately shifts to the solicitor in that example.
Yes. The burden shifts to the party presumed to have influence to show that the transaction was, in fact, the result of the claimant's free, independent, and informed decision. They have to rebut the presumption.
And how do they do that?
The most common way is by showing the claimant had competent, independent advice before entering the transaction. If they can show the claimant fully understood what they were doing and its implications, usually because a separate advisor explained it, that can rebut the presumption. For small, insignificant gifts, the presumption might not even arise, but for substantial transactions, rebuttal is crucial. As Lord Nichols put it, the greater the disadvantage, the stronger the evidence needed for a rebuttal.
Okay, that's the first route to presumed UI, the automatic relationships. What's the second way?
The second way covers all other relationships where influence isn't automatically presumed by law. Think husband and wife, cohabitees, engaged couples, bank manager and customer, carer, and elderly person relationships where influence might exist but isn't assumed.
So what does the claimant have to prove here?
Here, the claimant has to prove two things to raise the evidential presumption. First, they must prove that, in fact, on the specific evidence of their relationship, they generally did repose trust and confidence in the other party, or that the other party had ascendancy over them. They have to establish that specific dynamic existed.
So prove the trust relationship actually existed de facto.
Yes. And second, they must prove that the transaction they entered into is one that calls for explanation, or, as it was often put before Ettridge, was manifestly disadvantageous.
Ah, so this is where disadvantage does come in for presumed undue influence.
Yes. In the second category, the nature of the transaction is critical to raising the presumption. If the transaction looks odd, improvident, or clearly against the claimant's interests, why would someone guarantee a huge debt for someone else for no benefit? Why gift away their main asset? That disadvantageous or inexplicable nature is what makes the court suspicious.
It cries out for an explanation, and if the only explanation seems to be the underlying influence, the presumption arises.
Exactly. The disadvantage isn't a separate legal requirement after the presumption is raised. It's often the key piece of evidence that helps raise the presumption in the first place by making the transaction inexplicable without influence. So, claimant proves. 1. Relationship of trust-confidence, AD. Transaction calls for explanation, often because it's disadvantageous. If they prove both, the evidential burden shifts.
And the defendant then has to rebut it, again, probably by showing independent advice.
Precisely. The best way to rebut the presumption, once raised, is to show the claimant acted freely and with full understanding, usually demonstrated by evidence of competent, independent legal advice. Ettridge really emphasized the importance and the expected quality of that advice.
Okay, this brings us back to third parties, like banks. This seems really relevant for undue influence, especially the husband-wife scenario you mentioned.
Hugely relevant. This is where O'Brien and Ettridge had their biggest impact. Think about the common situation. Husband, H, needs a loan for his business. Bank, B, agrees, but wants security. H persuades wife, W, to agree to use the jointly owned family home as security. H might unduly influence W to sign the mortgage documents. The undue influence is between H and W. But W wants to set aside the mortgage contract she signed with the bank, B.
Can she do that? The bank didn't exert the
You
influence.
might be able to, yes. She can set aside the transaction with the bank if the bank had either actual notice or, more commonly, constructive notice of the husband's potential undue influence over the wife.
Constructive notice, meaning the bank should have known or should have suspected.
Exactly. The bank is put on inquiry. O'Brien established that a bank is generally put on inquiry whenever a wife offers to stand surety, provide guarantee or security, for her husband's debts, or indeed in any non-commercial relationship where one person provides security for another's debt and the transaction isn't obviously to their financial benefit.
Why? Because there's an inherent risk of influence in those situations.
Yes, the relationship itself, combined with the nature of the transaction, one person taking on risk for another's benefit, raises a red flag. The bank should realize there's a risk that the wife's consent might not be fully independent.
So once the bank is on inquiry, what must it do to avoid being bound by the wife's claim of undue influence? They can't just ignore the red flag.
No, they can't. Ettridge, Note 2, laid down detailed steps the bank should take to protect itself and ensure the wife's protection. To avoid being fixed with constructive notice, the bank need to take reasonable steps to satisfy itself that the wife understands the practical implications of the transaction and has had proper advice.
What are those steps?
Broadly, the bank should communicate directly with the wife, insisting she gets independent legal advice from a solicitor. Provide that solicitor with the necessary financial information about the husband's debts and the proposed loan. Get written confirmation back from the wife's solicitor confirming she has been properly advised. Crucially, Ettridge emphasized what that advice should involve. The solicitor must meet the wife privately, without the husband, explain the documents, the risks she could lose her home, the seriousness of the commitment, and confirm she understands and is proceeding freely. The solicitor then certifies this to the bank.
Wow, that's quite a process. It puts a real responsibility on the bank and the solicitor.
It does. It's designed to ensure the wife's consent is informed and voluntary. If the bank follows these steps, they are generally protected, even if undue influence did occur between husband and wife. If they don't follow these steps after being put on inquiry, the transaction, the mortgage or guarantee, is likely to be voidable against the bank by the wife if she can prove undue influence by her husband. Cases like Patton v. Bevan Ashford have further discussed the solicitor's duties in this scenario.
Okay, that's really clear. The Ettridge Protocol is vital for banks in these surety situations.
Absolutely critical.
So let's sum up undue influence. It's equitable. Focuses on the relationship and preventing abuse of influence. Broader than duress, doesn't need overt threats.
Check. Divided into actual undue influence, prove the specific improper influence, disadvantage not needed, and presumed undue influence. Establish facts about relationship and transaction to raise a presumption, shifting the burden.
Presumed UI arises either from specific legally recognized relationships, like solicitor-client, doctor-patient influence presumed, disadvantage not needed to raise it, or from proving a de facto relationship of trust confidence, PLUS, a transaction that calls for explanation, where disadvantage is usually key to showing it's inexplicable.
Check again. And in presumed UI, the defendant needs to rebut the presumption, usually by showing independent advice. And for third parties like banks in non-commercial surety situations, they're put on inquiry and must follow the Ettridge steps to ensure proper advice is given, otherwise the transaction is voidable against them.
And just like duress, the remedy is rescission, making the contract voidable at the victim's choice, provided they act promptly.
You've nailed the key elements. 3, comparing and contrasting. So we've looked at them separately. Let's just quickly pull the threads together. Duress versus undue influence.
Okay. Duress, common law. Focus on illegitimate threats pressure during formation or modification. Usually needs unlawful pressure. The lawful act duress is a rare, tricky possibility.
Undue influence. Equity. Focus on the relationship, preventing abuse of trust or ascendancy. Doesn't need overt threats, can be much more subtle.
Big similarity. Both make the contract voidable, not automatically void.
Yes, absolutely key. And flowing from that, in both cases, the victim needs to act reasonably promptly to rescind once free from the pressure or influence, or they risk affirming the contract by delay.
Key difference.
Mm-hmm.
The role of disadvantage. Not needed for duress, not needed for actual undue influence,
Right.
but often crucial for presumed undue influence in the second category, the de facto relationships, because disadvantage helps show the transaction was inexplicable and triggers the presumption. It's not strictly needed for the automatically presumed relationships, but the level of disadvantage there impacts how easily the presumption is rebutted.
Excellent summary of that point. And the method of proof is different. Positive evidence of coercion for duress actual UI versus establishing the relationship and circumstances to raise a presumption for presumed UI, shifting the burden, applying the concepts, sample questions.
Okay, let's quickly apply this. The source materials had some sample questions. Good practice for exams.
Definitely. The first one asked if courts should even bother intervening with economic pressure, calling it futile. That really tees up the whole debate we've had.
Yeah, it forces you to discuss that line between tough bargaining and illegitimate duress. We've seen courts do intervene, right? It's not futile, but it's difficult.
Exactly. You talk about the development from cases like the Saboan and the Atlantic Baron establishing economic duress, the theoretical wobbles over the overborne will idea, the current compulsion plus illegitimacy test, and the difficulties highlighted by lawful act duress in times travel. You'd argue why courts intervene policy reasons about preventing exploitation, even if defining the boundary is hard. Maybe even link back to the policy hints in Stilk v. Myrick.
It shows the law grappling with unequal power in the real world.
Precisely. The second question was that scenario with R and S. Living together, R is domineering, S relies on R financially. R gets S to transfer property rights, apartment userant for some shares. They split up, S wants the property back, but oh dear, the shares have gone up in value.
Right, this screamed undue influence from the start.
It does. So you'd analyze, can S prove actual undue influence? Need evidence of R's capacity to influence, the influence exerted, it being undue, and causation. The big plus for S here.
Does need to prove the deal was disadvantageous.
Yeah.
CIBC Mortgages v. Pitt, Ettridge.
Exactly. Because the shares went up, proving disadvantage is impossible. So actual UI is the route where the outcome doesn't matter, only R's conduct.
But what if S can't prove actual undue influence? Maybe the evidence just isn't there.
Then S tries presumed undue influence. The relationship, cohabitees, financial reliance, isn't automatically presumed, so S must first prove the de facto relationship of trust and confidence. Lloyd's Bank v. Bundy style.
Okay, maybe possible, but
Then S needs the second element. The transaction must call for explanation, be inexplicable without influence. And here's the killer blow we discussed. Because the shares increased in value, the transaction was financially advantageous to S.
making it very hard to argue it was inexplicable or disadvantageous.
Exactly. It provides a rational explanation for S agreeing potential financial gain. This likely prevents S from raising the evidential presumption under the second limb of presumed UI.
That's a fantastic illustration. The financial outcome kills the presumed UI, inexplicable transaction route, making actual UI the only real hope, even if harder to prove.
Precisely. It shows why knowing the different requirements is so important.
And the quick quiz questions hammered home key points. Factors for duress from pay on, definition of actual UI, no disadvantage needed.
Yes, and crucially, the Ettridge guidelines for banks being put on inquiry, needing to ensure independent advice for the wife's surety. That's bread and butter for problem questions involving guarantees.
And the remedy for UI being rescission, making the contract voidable, same as duress.
All core concepts reinforced. Conclusion. So there we have it. A deep dive into the landscape of duress and undue influence. They really are essential checks and balances on the basic principle of freedom of contract. They try to ensure agreements aren't just formally signed, but reflect genuine, uncompelled consent.
Understanding that difference, legitimate pressure versus illegitimate pressure or undue influence is absolutely vital. And knowing the consequences, too. The contract is voidable, and you have to act fast to undo it.
The way economic duress has evolved, the struggles with lawful act duress, and especially the detailed rules around presumed undue influence and third-party notice stemming from massive cases like Ettridge, No. 2, they all show the law trying its best to adapt to complex, modern commercial and personal relationships.
It's definitely clear these aren't simple black and white areas. You really need to look closely at the specific facts, the nature of the pressure, the details of the relationship.
You absolutely do. And mastering these details, knowing the key cases and how to apply the test, that's crucial for getting to grips with contract law properly.
Well, this deep dive into duress and undue influence has certainly given us, and hopefully you, a lot to think about. It really highlights that tightrope the courts walk.
That balancing act, yeah. Upholding contractual certainty on one side, protecting parties from unfair pressure or abusive influence on the other. It's about the integrity of the agreement process.
Which leaves us with a final thought, maybe. Given how hard everyone admits it is to draw that precise line, especially between tough but okay bargaining and illegitimate economic pressure or subtle influence versus genuine advice. Are these doctrines, as they stand, really achieving the goal of ensuring genuine consent effectively? Or does the inherent uncertainty sometimes create more problems than it solves for businesses and individuals trying to make agreements?
That's a good question to ponder. How effective are these tools in practice, and could they be clearer or applied differently? Something for you to mull over as you reflect on these principles.
We really hope this deep dive has been helpful in clarifying these important and often examined areas for you.
Remember, this deep dive was based on materials made available by the University of London, and we thank them for that. This session was brought to you by Sinorbit Academy, Sri Lanka.
Thank you so much for joining us. And one last time, to everyone studying, good luck with your studies and upcoming exams.